like Mustang man.
I think her part is over. Now, so now you'll be arguing on the death reference. After that, she will again give a reply.
That's it.
Okay.
That is it.
Okay. She's unwell.
No, unwell. She's unwell. Give me a call.
Okay. Okay.
Wait, please, my lord, here in this case, my lord, why amicus curiae is appointed? Normally, my lord, when my lord, the accused is represented by a competent lawyer, and usually, my lord, it is not necessary to engage in, but there is a judgment of the Honorable Apex Court, that is 2019-20 SCC, and that para 3.2, that clearly, my lord, indicate that 2019-20 SCC.
2019-20 SCC.
2019-20 SCC.
Page,
my lord, 196.
196.
196.
Para 3.2.
3.31.2, my
31.2.
I'll read that, my lord. It is, my lord, in para 31. Before we part, we must lay down the certain norms so that the infirmities that we have noticed in the present matter are not repeated. 31.1. In all cases where there is a possibility of life sentence or death sentence, learned advocate who have put in minimum 10-year practice at the bar alone be considered to be appointed as amicus curiae, though legal service to the representative accused. 31.2.
SCC. Yes, just a moment.
One.
1920 196. Anokhi Lal. Although we don't know the citation, but we are aware that there is a direction of Supreme Court.
That's right.
Thank you. Thank you.
Your lordship kindly see please my para 31. Para 31. The 11th is my 31.2.
Yes.
In all matters, if the High Court concerning the confirmation of death sentence, senior advocate of the court must be first be considered to be appointed as the amicus. So accordingly, my lord, I was taken consent, my lord, and I was being appointed. That's why I'm before your lordship today. So, my lord, here in this case, here about my lord, almost my lord, 21 witnesses were examined, my lord, but there is not a single eyewitness. The conviction is absolutely based on circumstances. There is no eyewitness, my lord. And your lordship kindly see regarding my lord saying, probably my learned DP also submit and my learned can also submit.
Because if normally the thumb rule is that on circumstantial evidence, unless there is a very clinching evidence available, death sentence should not be awarded.
Should not be awarded. That is the law, my lord. But Here, my lord, there are 5 case instances, my lord, where circumstantial evidence on the basis of the death sentence was awarded. That was, my lord, considered by the learned time. Come to that, my lord. Before that, my lord, regarding sin and submitting, well, already, my lord, evidence are read, my lord, everything loyalty to here in this case, my lord, very vital, my lord. Then, according to me, my lord, the circumstance, my lord, that is sin is completed. Sin is completed, and my lord, one most vital evidence that is leading to discovery. In PW3, my lord says going towards the land, and PW1, PW12, PW19, PW21. And from that, my lord, your lordship, my lord, the same is, my lord, your lordship, PW3, PW1, PW12, PW19, PW21. Because PW21, there is a serological test, evidence of human birth. I'll come to that, my lord. So exhibit 20 was the doubt. So exhibit 20 is the doubt. How that was discovered? That was discovered, my lord, leading to discovery. There is a leading to discovery as per section 127 of the Evidence Act. All the formality has been fulfilled, I have seen. And your lordship kindly some stateway goes to page 212, my lord. That is the 161 statement of the, my lord, accused.
Paper book.
In the paper 212.
Better volume. No, I don't know. Paper was right a case. 1, 2, 3, 4. So suicidal. Yeah.
My lord,
Page
212.
Yes.
My name and age, address in two as mentioned above. My house is located at the plain area of Batsura. We have little nut plantation on the hillside of Batsura. Yesterday about 10 a.m. I went to see our newly made little nut plantation near the house of King Rang Rihang, holding a EAW in my hand, Dao in my hand. I walked through the hill. I walked through the hill train until I reached the house. Holda Ranga. I went to house of Holdana Ranga. Found that Holna and his wife were not there. His daughter Anjali Ranga and Dilip Kumar Ranga were about at home. While I was sitting at their house, Rasmi Rangan, Rasmani Rangam, who is the relative of this, also came to their house. I had some formal talk with him. And after some time, I went towards our newly cleared hilly area near the house of Ini Rang Riang. I reached our cleared place and but could not find nobody work there. Actually, the laborers were supposed to be engaged for clearing the unwanted plant, but they were nowhere to be found. So I returned from there and proceeded directly to the house of Kini Rang Rang. As I reached their house, I saw that she was wearing some traditional cloth by sitting on the floor of the house. As I entered she got offended and asked me to go get out, but I entered. When I tried to grab her, she got up from the floor and tried to assault me, but she could not as she was only little girl. I then told her to open her cloth at the edge of my dove, but she resisted and told me that she will complain the matter to all the local people. I insist, and when she tried to help, I grabbed her mouth and placed her back on the floor while all my might and then caught her throat with my dove. After holding her for a minute, we saw the collapse, and I then looked inside seeing nobody. I escaped from the house and moved on downhill toward the stream. Then the stream I located about 100 meters downhill. I washed my dove in the stream, and after the blood stain was removed from the dove, I again moved carefully, taking different paths till I reached the house of Surendra Yang again. Desmai Yang, whom I left at Holendra house, was still present. I saw another fellow called Kadir inside their house. Rasomani came out and started proceeding downhill toward his home, and I called him came along. I followed Rasmani and reached my house. On reaching home, I keep my dove below a wooden table. After some time, the news of death spread all around the locality. I also went to see the dead body like other people, but when I came to know that the people started suspecting me, I decided to keep away from the place. But all the local people have decided that they will catch me where they find me, and finding no way out, I surrendered before the local people, who handed me over to the police yesterday. I have committed the crime. I do not know what was going through my mind that point. At that time, once again I say I kill her to hide all possible evidence. This is my statement. So that was the statement, my lord, leading to this. So, my lord, regarding same, my lord, and if your lordship, my lord, put that leading, because that was recovered and that was examined to the examined by FSL, and there is a possibility of there is a stain of, my lord, human blood. So far is, my lord, that same, my lord, that I am not going to describe elaborately, my lord. Already my learned and also my lord argued very well. Now, my lord, your lordship kindly see, it is admitted position that there is no eyewitness, only on the basis of the circumstantial evidence, my lord, conviction has been covered. Now, my lord, your lordship kindly see the judgment, my lord, considering 5 judgments. Considering that page 170. 170, your lordship kindly see. (170) of the paper book, my lord.
Yes.
Now I am affirming myself most respectfully some of the case like this, where the Honorable Apex Court confirmed death sentence. 1. The state of UP was Satish. The Honorable Court was upheld and death sentence was awarded to the accused who committed rape of a child of 6-year-old, followed by murder, holding that the case was within the category of the rarest case. Second, That is in case of, that is 2009 5 SCC 740. The, the accused committed rape on 10-year-old minor girl, and as he had feared that she would disclose the incident to the others, he had killed her, and where the Honorable Justice Wajid Pasha and Justice Supreme Court of India will appeal the death sentence or the conviction. That, my lord, 2009 5 SC 740, your lordship kindly see the judgment, my lord. That, my lord, slightly is not correct. 2009 5 SC. 2009 5 SC. Your lordship got it, my lord. 2009 5 SCC
Paragraph?
740.
Yes.
Your lordship kindly see in that case, my lord, page para 120. Para 1. We agree with the lordship that the appellant has, my lord.
Just 120. Yes.
Para 120. So descending was there.
Just yes.
You know, the last portion.
Hmm.
So the both of us had agreed with the conviction to be maintained. Conviction was appealed. One of us, Pasayat J, has confirmed the death sentence, while Ganguly J has held that life sentence is to be given. The matter is referred to the larger bench only on the question of sentence. Conviction was upheld, my lord. Only on the sentence, my lord, regarding my lord death sentence. That was, my lord, matter was placed before the Honorable Chief Justice of India for a necessary order. So then it was, my lord, heard regarding that, my lord, regarding my lord death sentence, my lord, it was referred to the third judge. So then, my lord, that is reported in 2011 to SCC. 2011 to SCC.
Okay, just now.
2011 to SCC 764.
764.
764. So it was referred to the third, sorry. para 12 my.
Yes.
Para 12 my lord. We are therefore of the opinion that the appellant herein ought to be awarded a similar sentence. We accordingly commit to the death sentence awarded to him to life, but directly the life sentence must extended to the full life, and the appellant ought to be subject to any emission or commission at the instance of the government of the good sufficient reason. So, my lord, that sentence was, my lord, converted to the life for whole period. So accordingly, that judgment which was mentioned that it was appealed. So that was not correct, my lord. So that was by 2011 to SCC. It was, my lord, only, my lord, life sentence was life sentence was, my lord, appealed, my lord.
No, but here in this case, this Rathod, paragraph 7
Fine.
of this judgment,
Which one, my lord?
paragraph 7 of this 2011.
My lord.
So the reason is not otherwise. The reason to commute
My lord.
is that he was not heard on what you call sentence. Otherwise, the Supreme Court would have given that punishment, but just because of that, because you see, otherwise, under the what you call under the CRPC, normally by not hearing, non-hearing of the accused on sentence would vitiate the proceeding. So, so it would have otherwise remanded back for a sentence hearing.
My lord.
But
That will be demanded for yes.
But the Supreme Court did not do it. Rather, it committed.
Yes.
So therefore, otherwise, the presumption is that the Supreme Court would have upheld the sentence.
What I am submitting, my lord, there are 5 cases they have cited.
No, I understand. Your context is different. Your context is different. You are saying that he has relied on it, but that was subsequently.
Yes, that is all. So, and that point. Yes, the facts are different. Yes, the point of sentence of the hang also, my lord, he has heard. But it was not hard, that's why, my lord, it was not been. So that is 2009. Then another one is, my lord, in page 217, that is, my lord, 1994 CSC. So, my lord, that is another one is, my lord, 1994 to SCC 220, that Dhananjay Chatterjee's case. That is the case I know, my lord, that is executed. Other I don't know whether executed or not, but this is Dhananjay Chatterjee case was, my lord. That is the on the basis of circumstantial evidence, my lord, death sentence was awarded, but he was hanged, that is executed. My lord, all other cases, my lord, that is another case, my lord, 2007 for SCC. That is this 5 cases, my lord, relied by the runner trial judge, my lord, regarding point of death sentence.
Yes.
My lord. Sorry, my lord. My lord, that after the, my lord, that law commission report, my lord, that everything has been changed, my lord, from 2015, my lord. 2015, my lord, there is a law commission report. That law commission report, my lord, that report was, my lord, 262 law commission report. After August 2015, my lord, that the law commission, my lord, recommended my lord, I just more synopsis, my lord. That will be, I think, everything, my lord, I have put it here. It will be, my lord, in this, my lord, I have made a small,
Abolition of death penalty
my lord,
for the offenses except those related to terrorism.
that report I have annexed in my book.
Hmm.
Legal logic, kindly, my lord, one book to that my. That law commission report will also, and last but three, please. Last but three. The Law Commission of India's report on death penalty.
Yes.
The Law Commission of India in its 262 report, August 2015, recommended that the death penalty be abolished from all the crime other than the terrorist related offense and waging war. Complete recommendation for a report as follows. So these are the report, madam. In fact, my lord, that from very beginning, my lord, inception of the my lord society, my lord, the death penalty was, my lord, in everywhere in the world, my lord. But now, my lord, only in 86 countries, my lord, still, my lord, death sentence is, my lord, prevail. In other countries, my lord, it is already abolished.
Out of these three countries whose names start from Saint, they have retained it. But this law commission report on death penalty was not accepted. This recommendation was not accepted by the government.
Till today.
No, no, it's not accepted.
Till today, yes.
Yeah. 2015.
Yes.
Because we are not getting the details of the parliamentary debates.
Yes, my lord, debates are, my lord, time to time, debates are going on, my lord, and the lordship, my lord, and that full report is with me, my lord. And as a result, my lord, what I am submitting, my lord, the lordship can say very last page, my very last page in that my state compilation, very last page. Thank you.
Sorry. References. Lok Sabha. Not for publication. Incidentally, the reason we are smiling is we have in our hand a reference note laid before the Lok Sabha Secretariat
My lord.
for use of the members of parliament. This has a note written here, this side, not for publication.
But it is public everywhere. Even though that I have
No,
also-
no, I'm having it in hand, not to be published. What was not to be published is in my hand. But I don't find the recommendation accepted.
No,
So
but
for the time being, that sentence is there.
yes, no, that sentence is there. It still prevail, my lord. That's why, my lord, I'm submitting your lordship. Kindly see the last page of this, my, you know,
This compilation, yes.
up to 2022, 539 cases of death sentence, my lord, still pending for execution. So that is, my lord, in that, your state-wise backup is there, my lord. Including Assam, my lord.
I think our registry can take up suo
Assam
moto.
12.
Our registry can take up suo moto.
My lord. But because of, no, there's some reason, man. Some cases are pending before the honorable apex court from some point regarding mitigating point, my lord, what is the criteria to be adopted? I'll place that. So that judgment is still pending.
Okay.
So these are the scenario, my lord, as a result, my lord, because it is more harmful, my lord. A person who was, my lord, convicted and his death sentence is hang on his head, but he's in the my lord,
Limbo.
that is very dangerous, my lord. And last but one para, my lord, last but one page also, my lord, death sentence regarding I made a statement, my lord. So normally, my lord, regarding death sentence, my lord, two theories, my lord, considered the balancing of aggravating circumstances and mitigating circumstances. And second is, my lord, that is rarest of the rarest case. These are the two components, my lord, always taken into consideration.
Circumstances and
And my lord,
Aggra-
balancing of mitigating circumstances and aggravating circumstances.
yes.
In my compilation, my lord, from my point of view, my lord, what are the aggravating circumstances and what are the mitigating circumstances? I have established, although there is no definition, and you will find page number 3.
Page number?
Hello?
Page number?
So there is no page number.
Oh, acha.
Page number 3, my lord.
3. Okay.
So that is that is actually my reason submission.
Okay.
Maybe you can take into
Okay.
consideration. My lord, that is my submission.
Hmm.
So aggregating circumstances, mitigating circumstances are clearly that mentioned there, my lord. After reading the evidence, I find that these are the,
Yes.
and then I will come to the judgment which I have closed, my lord. One by one, I have mentioned, and regarding 11th para also I have my lord put it there.
Okay.
So that's why I am not giving any much trouble to your lordship. The 11th para, my lord, and some of the judgment we have not put it there, my lord. Because after reflection of that, my lord, I have noticed some judgment, and these are the.
In one of the very recent cases, a three-judge bench of the Supreme Court of India had converted into the death sentence into life, and said that a question was formulated that 14 years was grossly inadequate,
Yes.
and therefore it said that this court would have the power to, this court means Supreme Court, would have power to impose a larger sentence, larger than 14 years
My lord.
sentence. Sorry, greater sentence would be a correct word. And in that case, the Supreme Court has considered almost, I think, more than 15-20 cases, all of a death sentence.
That is, so
This is that citation is it's reported in crimes. I don't know about. I think SEC it would have come. It is Sundar versus Sundar alias Sundar Rajan.
Sundarajan case, my lord, that let me get
I have the crimes citation.
crime sheet.
Crimes citation is 2023 2 crimes Supreme Court 29. In 2023 volume 2 crimes within bracket SC, then 29.
Really, my lord, after passing the judgment, this is the way that it is for the execution, my lord. In the meantime, my lord, some application has been filed for that case, my lord, and again it was, my lord, forwarded to the larger bench, and that situation, my lord, I'll come to that, my lord. I'll place one judgment. That is, my lord, on my lord, September 19, 2022. that I will come to that. But before that, your lordship kindly see my compilation, my lord. Para-wise, my lord, and 11 para I have stated, my lord, everything stated, and other judgment which I have relied, my lord. That is my lord in my that book of release that I have already given to your lordship.
It is there in SCC online. SCCL online is 2023, SCC online 310.
Online. But this two I will come, my lord, this judgment, my lord. I'll come. So my lord, on my in the September, my lord, 2022, Honorable Apex Court, my lord, take a so much of that so much of Nikatan matter was my lord there. In that case, my lord, regarding framing of guidelines and regarding potential mitigating circumstances to be considered while imposing the death sentence.
Yes.
That so much of judgment, my lord.
Yes.
And in that judgment, your lordship kindly see that regarding framing of guidelines.
Framing of guidelines. Yes.
Potential mitigating circumstance to be considered while imposing death penalty. In that case, my lord, your lordship will be ready for the last page. That no, my lord, no action, no, my lord, decision has been taken. And considering the entire matter, my lord, it was sent to the larger bench. That larger bench is yet to be constituted. Matter number 23 is very important, my lord.
23.
23.
Conflict of two opinions.
Yes, in reply to the above, the excessive clear conflict of opinion by two sets of three judges bench decided on the subject. The notice before is court of the question had taken into consideration that finding of fairness afforded to the conviction by a separate hearing as an important safeguard to the upon the imposition of death sentence. This layer of the real case by relying on the recommendation of the 48th Law Commission of the court. It is also fact that all the cases were imposing the capital punishment is a choice of sentence. The debating circumstance would be always be on record, and it will be a part of the prosecution to evidence leading to conviction, where the accused can be separately executed the place mitigating circumstance on the record. For this reason, that the stage of the doing so in harder conviction displays the conviction of the helpless disadvantage little and still having against him. This court is of the opinion that it is necessary to have a clarity in the matter and ensure the uniform approach to the question regarding granting real and meaningful opportunity. They opposed the formal hearing to the accused conviction on the issue of the sentence. Consequently, this court is of the view that reference to a larger bench of this honorable court judge is necessary for this purpose. Let the matter be placed before the honorable Chief Justice of India for applicable order in this regard. So that, my lord, I have checked it up, my lord, till today, probably that was not been. So my lord, in my compilation, my lord, everything I have, my lord, written there. So my lord, my opinion is that, my lord, it is not a fit case to, my lord, giving capital punishment. Considering the circumstance, everything, my lord, it may be a case of, my lord, life sentence, my lord, but only on that, my lord, it will be not proper, my lord. And if you have also going, my lord, balancing theory, and that is mitigating circumstance also, my lord, you can be handled. He's a young boy. Although he has a previous record of crime, my lord, that cannot be considered. That evidence also, evidence that would not permit, my lord.
Okay.
So my submission before lordship, my lord, it is not a fit case for him, my lord. And regarding the judgment, which is also SCC on that, I can't do it, my lord, which I
No,
require.
no, you did not spend your time there because in that judgment they only considered that mitigating circumstances and converted it into a life.
Life. Life means life.
Life is full life.
Full life. There is no
No, but there a reference was made that these 14 years would
No.
not be adequate in some cases, and therefore
No, 14 years to actually, my lord, that is misinterpreted. Actually, it is somebody always it is a that when a life means 14 years. What happened, my lord? 14 years mean after 14 years, he has a right to file a appeal before the government. And the probably article also that there is a provision in the CRPC also. So after that, government can reduce it. But that case, that is been same in case of Nalini, that is Rajiv Gandhi's murder's case. So When my lord, it was pardoned by the Gandhi family also, that he has not been released. Because considering that, my lord, government randomly in UP, my lord, all the great accused, my lord, they are suspended, they are released on, my lord, considering that. That's why, my lord, there is a guideline frame that if you give any remission, you have to take permission from the confirming court. Suppose the life sentence is confirmed by High Court, then they have to take permission from the High Court. If it is from the Supreme Court, then take permission. So that is the present scenario, my lord. That's why, my lord, 14 years is actually not there, my lord, not the sentence in case of my lord life. But after 14 years, he has the right to file it. So regarding the sentence, that is my sentence.
This here reference is made to, I'll show you this. This is in context, Mr. Das.
So,
No, that three-judge bench decision, which I was referring to, 2023.
2020,
This is the
receipt, my lord.
this is the paragraph. Here reference was made to a different earlier case, and this is the observation. This remission after 14 years by the government, that is also in cases inadequate, grossly inadequate. It was held.
That's why, my lord, in all cases, my lord, where my lord life sentence is, that means death sentence is converted to life, my lord. In that case, there is no remission. There is no remission. In a normal 302 case, my lord, life sentence, my lord, that is mean there is a death for remission. But in that case, my lord, always, my lord, quoted by the confirming court. Confirming court quoted that life means life. Yeah, I have seen the all cases where my lord death sentence was, my lord, reduced to life. That is, my lord, life means life.
No remission.
No remission.
Yes. Okay. Thank you. Mr. Mahanta, I forgot your certain counsel's name.
My ego.
Gogoi.
Torun Gogoi is the
Good.
name.
Yes, Mr. Udin, we have two things in common. The beard.
Yes,
Correct.
the coloring. Here, my lord. Before I proceed with my submission, we are looking kindly for a moment in section 316.
316,
68.
68. Raj, CRPC. Oh.
In any case submitted under section 366, the High Court may confirm the sentence or pass any other sentence warranted by it. May annul the conviction and convict the accused of any offense of which the Court of Session might have convicted him, or order a new trial on the same or on amended charge, or may acquit the accused. And 386, almost similar. 386 is the power of appellate. They are also in an appeal from an order of acquittal, reverse order, and direct the further inquiry or may appeal from conviction, reverse the finding of sentence and acquit or discharge the accused or order him to be retired. So power under 386 conferred to the appellate court and power referral court under 368 are almost similar. Here, both the court has power to confirm, to reject, to alter the sentence, to acquit the. So, I have already argued on the point of acquittal. The appeal I have already submitted my details. And my entire submission was that that sentence confer question will come when it is decided that yes, there is a market by the age. But I had my limited asset, my try to assail the findings that in fact there is no murder by the this fact has to be. So on that point, my submission is that now, as regards your lordship, already my amicus curiae has placed. I was also with this recommendation of law commission under 262. Here I have found the commission consisted of more than 11 members. And the recommendation, my lord, a dissenting view was given by one member. And your lordship is my, and this member is my lord. Your lordship will find annexer A, my lord, page 222. And this was given by Justice Usha Mehra. According to, out of 11, one member has given dissenting view of the recommendation, my lord. And this opinion is that paragraph 2 and 3, page 220. Who said that while deciding a case and imposing that sentence, there is error in the judgment or it is discriminatory to my mind is very general statement. Moreover, where is human? Almighty alone is the dispenser of absolute justice. Judges of the highest court do their best, subject of course to the limitation of human fallibility. But that does not mean that the provision of death penalty should be abolished in all cases, irrespective of gravity of any of it. Even otherwise, by the time case reaches Supreme Court, it passes the scrutiny by High Court, which confirms that on reference being made by Session Court. Kidnapping by terrorism for ransom or creating panic amongst the people and for securing release of their associates and others assume serious dimension. Menace of kidnapping and abduction of ransom is on increase. Therefore, in its wisdom, punishment of death penalty has to be there on the statute book. To say that innate disposition of human mind that control, manage and administer such punishment, thereby making them inevitably arbitrary, is not correct. Again, we lose sight of the case of like Ashok Afzalpur. They pose threat to security, safety and peace of the society. So many innocent lost their life. In such cases, extreme punishment awarded on the doctrine of the arrest of the rare case cannot be called arbitrary or discriminatory. In fact, the report too much emphasis has given on human right principle of person subjected to death penalty, at the same time forgetting the human right of innocent victim. As already pointed out by me, above possibility of error should not be the reason to abolish death penalty. Supreme Court in Bachchan Singh case expounded the doctrine and rarest of the rare principle, which is withstood the test of time. It has neither failed nor faltered. What other sanctions would have been given to Mithari? In such cases of heinous crime, extreme measures are required by giving them harsh punishment, keeping in mind the safety and security of the society. So, descending the event one, it should be based on Bachchan Singh case. What is there, Your Lordship? And this recommendation, Your Lordship has already said that it is not accepted by the Parliament. The Supreme Court, my lord, I have found.
Yeah, just a minute.
Supreme Court has accepted, my lord, up to some extent, this recommendation of the Law Commission. That is reflected in its judgment reported in 2019 12 SCC 438. Chanulal Burma versus State of Chhattisgarh. Paragraph 23. And Your Lordship will find at page 457 of the judgment. Paragraph 24.
Para 24.
2019 12 SCC 438.
Yes. Para
Para 28. This is
28. Okay.
I am sorry, my lord. Para 24.
24.
Page, Your Lordship will find 457. After recommendation. Recommendation has been quoted. after recommendation.
Yes.
Having regard also to the said report of the Law Commission that the constitutional regulation of capital punishment attempted in Bachchan Singh has failed to prevent that sentence from being arbitrarily and fixedly imposed, and that capital punishment has failed to achieve any constitutionally valid penological goal. We are of the view that a time has come where we view the need for death penalty as a punishment, especially its purpose and practice. It is also a matter of anguishing concern as to how public discourse on crime have an impact on the trial, conviction, and sentence in a case. The court's duty to be constitutionally correct, even when its view is counter-majoritarian, is also a factor which should weigh with the court when it deals with the collective conscience of the people or public opinion. After all, the society's perspective is generally formed by the emotionally charged narrative. Such narratives need not necessarily be legally correct, properly informed, or procedurally proper. As stated in the report, such and such, the court plays a counter-majoritarian role in the protecting individual right against majoritarian impulses. Public opinion in a given case may go against the values of rule of law and constitutionalism, by which the court is nonetheless bound. And as held by the court in Santosh Barrier, public opinion or people's perception of crime is neither an objective circumstances relating to crime nor to the criminal. In this context, we may also express our concern on the legality and propriety of the people engaging in a trial prior to the process of trial by the court. It has almost become a trend for the investigating agency to present their version and create a cloud in the collective conscience of the society regarding the crime and criminal. This undoubtedly puts mounting pressure on the court at all the stage of the trial, and certainly they have a tendency to interfere with the due course of justice. Till the time death penalty exists in the statute book, the burden to be satisfied by the judge is awarding this punishment must be high. The irrevocable nature of the sentence and the fact that the death row convicts are for that period hanging between life and death are to be duly considered. Every death penalty case before the court deals with a human life that enjoys certain constitutional protection, and if life is to be taken away, then the process must adhere to the strictest and highest constitutional standard. Our conscience as judge, which is guided by constitutional principle, cannot allow anything less than that. These appeals are hence partly allowed, commuting the death sentence to life imprisonment.
Again, this next paragraph, 28.
This is by
Last four lines. At page 459.
has failed to
459. So and so has failed to prevent death sentence.
prevent death sentence from being arbitrary and fractiously imposed, and that capital punishment has failed to achieve any constitutionally valid penological goal. We are of the view that a time has come where we view the need for death penalty as a punishment, especially in the purpose and practice. So purpose and practice, that purpose, why? It is already, the first, before I go into the judgment, I had pointed out the dissenting view. And Honorable Judge giving dissenting view has said that the Bachchan Singh case, the racial mitigating circumstances and aggravating circumstances have been discussed.
So there is no dissenting judgment here.
Dissenting, no,
One paragraph dissent.
the dissenting view in the report given. In the report I had, first time I had given to you, Justice Mehra.
Oh, acha, that view. Okay. Okay.
So, yes, it is. The report also does not recommend that it should be fully abolished. it is, report side, it is to be there, but it is for, it should not be generalized for, in all the state, on all matter case, as 302 says, death or life imprisonment, it should not be the mere case. So that part has already been dealt in the Bachchan Singh case. And in paragraph 8 of the present judgment, that part has been discussed in Bachchan Singh case. Mitigating circumstances, aggravating circumstances, and paragraph 8 of the judgment. Aggravating circumstances, if the murder has been committed after previous planning and involves extreme brutality. If the murder involves exceptional depravity. If the murder is of a member of any armed force, while such member of public servant was on duty. In consequence of anything done or attempted to done by such member, if the murder is of a person who had acted in lawful discharge of his duty. So these are aggravating circumstances. And mitigating your logic kindly. See the next below. That the offense was committed under influence of extreme mental and emotional disturbance. The age of accused, if the accused is young or old, he shall not be sentenced to death. So 25 years, my lord, here, my lord. The probability that the accused would not commit criminal act or violence as would constitute a continuing threat to society. The probability that the accused can be performed and rehabilitated. The state shall by evidence prove that the accused does not satisfy condition. So that's what are not there. That in fact the circumstances of the case and the accused believed that he was morally justified in committing the offense, that the accused acted under duress or domination of another person. That the condition of the accused showed that he was mentally defective and that the said defect impaired his capacity to appreciate the criminality of this. So, adding to the submission of London Amaike Suriman, I will say that it is not a case fall under the category of the realist to be there. This is my answer.
But Mr. T.J. Mahanta, Senior Counsel, this will be in death reference case. Mr. T.J. Mahanta, Senior Counsel, and amicus curiae in the matter, assisted by Mr. T. Gogoi, Counsel for the D. Gogoi Counsel. So his argument is concluded and written note of submission has been filed. The same is kept on record. The submissions of Mr. A.I. Uddin, learned counsel for the accused convict, who is the appellant in the connected appeal, has been concluded. Next para, Mr.
In this matter,
Oh, no, it's okay. I forgot your name. Mr. K. Bush, has submitted that Mr. Jahandan APP is holding the brief and she is indisposed and therefore prays for prays for an adjournment. Prayer is allowed. Next list on 30/11/2023.
My lord, may I pay for listing of a matter, my lord? Any date, my lord?
If I beg to mention a letter from motion regarding a cancellation.
Mention, please give it to the court master.
Mobile number. Item 10, 11, 12. Person paying for accommodation. If the engaging council is fine. The conducting council is indisposable of it. It's not bad.
10, 11, and 12. The 2014 matters.
But it's not bad. And if you could respond, not opposing the prayer of the person, and not opposing the lordship, and fix the matter on the next Tuesday.
Okay, list after we case prayed for Belgian counsel for the petitioner. Mr. A. Smith, the counsel for the respondent is present. Okay.
Date meeting next week. They release Tapli item 13 for withdrawal.
Okay. Upon instructions, Mr. B.D. Decker and counsel for the petitioner seeks to withdraw this petition. Mr. S.S. Roy Leonard, CGC is present. CGC for respondent 5 is present. So government who is there, you will be there. Mr. M. Setia, the government advocate is also present. So and so are present. This matter stands dismissal or withdrawal.
Okay. Supplementary item 14 for motion.
Well, your lordship, can you see page 20? Is the order of settlement, it follows from LOI dated 16/3/22. This is the settlement order for 2 years,
Page
22. This is the settlement order, first piece money, second piece money, third piece money, fourth piece money also we have taken. Now there is a, now the petitioner was facing a problem that your lordship will see at page 7.
Who's appearing for this? This is Forest. Who's appearing for Forest?
League हुए हैं ये district में।
Just SC Forest. Give us call. Just wait for some time. What you call you want the application to be taken up for surrender. That's what you want.
Yes.
Okay. Yes, Mr. Goway.
They have
What-
filed three applications, they have not considered it. My prayer is that they should consider it, and without considering, they should not take any consequence.
We are traditional saying about surrendering the deed, the complete area lot. This one, permit your lot. Permit if you lot it, Assam and the position goes, you are hurting a lot.
It's quoted at page 7. Or page 9.
Age?
Eight, nine,
Page 9
Nine.
and paper relevant provision, that is rule 16. But whatever they.
So this surrender of mining deed your lot. Of the mining deed, permit your lot. Give 2 years.
Northern Mineral Concession Route 2013. Which
160, your lot. For surrendering of a mining deed.
yes.
It says that the government can accept the request for leaseholder for the surrender of a lease or part thereof in case where the established that it is not that it has not been found feasible to operate a mining lease grant for whatsoever reason, subject to conditions that the lessee that is regular in furnishing the production reserve that's required in terms of resettlement. Number 2, has been taking the requisite step for the progressive mining project line as per the condition of lease grant. Number 3, is not in default of payment.
Mr. Goway, I don't find the what do you call the action of the respondents in a very good taste. You see, he has filed an application for surrendering. Now, to accept that letter, he has had to come to court. Is this a citizen-centric service? Yes. No, it's okay. But the non-acceptance is a citizen-centric act. So we direct him to go to Chief Secretary and give it. If the department is not accepting, no, you can say and reject it. You see, so you file an application before this court. We get it registered, and this court and the motion state dismisses it. So anything very, very hard on their part to accept it and pass any order. No, we'll ask him to come here. Who is the authority? Let him come here and accept it. For everything, we'll now call the forest department here. They will come to court, accept the letter. We'll ask the what you call PCCF to come here, accept his letter. He just wants to file this application. They are taking it, not acknowledging it. They are not passing orders. So we'll ask the DFO to be here, and the PCCF. For acceptance of letter, why should he come to court? No, no, we are not disposing it off. We are asking these officers to be here to accept his letter. Otherwise, they will not learn lesson. Friday, day after Friday at 10:30, 10:15, let your PCCA be here to accept his letter. We don't want it. He has come to court. He is showing us that he is not accepting. So we'll come there, call the PCCF here. Ask him to be here at 10:15. Otherwise, ask your PCCF that this is the order which the court is supposed to pass. You send a person at Mr. Das's client and accept it from there. Go to his office and correct it. If that is the citizen-centered service you are providing, then we'll ask all these officers, head of the department, all departments head to be in court at 10:15 a.m. to accept letters, to accept notices, to accept communication. They'll be here. Parties will file a writ petition, come with the extra copy here. We'll give it to all these officers here. We'll ask all the head of the department to be here. There's something is not acceptable. And the public perception is that the courts don't work. If I spend 10 minutes time here in this letter accepting business, I'll not be working anyway. You'll have to appoint 1,000 judges. If this sort of writ petition starts coming up, in the High Court, there will be 1,000 judges issuing notice to the officers to accept letters. Ask somebody to go to his office and collect it. The grievance expressed by Mr. P.T. Das Senior Counsel, assisted by Mr.
Page 7 is the main, because we have not given seven. Page 7.
No, B. Kalita. G. Kalita. D. Delhi. D. Kalita.
Page 7.
Is that
We are not getting the-
no? It's okay. Is somebody submitted that representation was given to the respondent numbers 2 to 4 on 5/10/2023 and 26/10/2023. But the
Also
same,
quoted.
huh?
Also quoted.
410. But 410 you can
Original application. Like there, 4.
no 410. Your prayer is to accept it.
Yes.
But you have not given that
That is our thing, correct, except 5 and
to accept the application. So you can't. You couldn't have given it. But the same was not acted upon. So the prayer in the writ petition is that is to direct the respondent authorities to accept the application dated 4/10/2023 for surrendering the lease in respect of Chapalmukh Kopili, KOPILI, NODI, sand permit area, part numerical 1 within bracket capital B of Nagaon district. This name is at page 14. Huh? Mr. R.R. Gugoi, done at Standing Counsel for the Forest Department, takes some time to obtain instructions. Next para. The alleged grievance of non-acceptance of application dated 4/10/2023 amounts to denial of citizen-centric service to the petitioner. Full stop. If the full stop, next, therefore, comma, notice is issued to the PCC have come, HOFF, that if their officers are not accepting applications, why the head of the department should not be asked to be present in court to accept letters and communications of the citizens. Next, the pendency of this writ petition shall not be a bar for the respondent authorities to accept the communication dated 4/10/2023 from the petitioner. Next para, based on Monday, or
The 14th, my lord, they will take action on, suppose if they do not pay the 5th kiss money. In fourth, we have gone. From the 4th kiss money itself, we are filing application that we are not getting proper appropriate quantity of sand. So therefore, please, I am surrendering it, please accept it. So therefore, they should not take any coercive action.
no, that we are not giving, because they will take it, they will accept your letter.
Let them accept what is that, tomorrow today is the last day. So they will say otherwise page 20, they will go. They are expert in that manner, because they will say security money deposit, then it will be forfeited, then the other amount, they will be forfeiting it, and they will put the petitioner into great difficulty. So they should not take any coercive action against the petitioner until they take a
No,
final.
but you see that for that we'll have to issue notice without hearing them kiss money. Today is the last day and tomorrow is the penultimate day. Huh?
On these holidays were there, let them take, without considering, they should not take. If they consider it, the things will be different. So my prayer is that without considering the representation, they should not take any coercive. Now, the provision of law is very clear, that if there is a provision for surrender, why my friend says, permit. Your worship will see the provisions of this minor mineral rules, section rules 3, 4, 5. There is no provision for separate provision for permit. These and permit all are same thing. From where my learned friend finds a separate thing. This is a settlement given if there is a provision for surrender. And there are cases where the petitioner was allowed to surrender. That separate things are there. My friend, I think without
No, let him take instructions. Come at 2 o'clock. At 2 o'clock, take instructions. Because to stay revenue, that's something.
no revenue, it will run now. I am not interested to run it because we cannot get the appropriate quantity of sand.
No, let him get instruction, because Mr. Das, what has happened is there in your communication, you are saying that the fifth kiss money,
Fourth
But,
money paid.
no, fifth kiss money falls due on 14th. 14th is today.
Yes,
So let him get instructions in the meantime at 2 o'clock. But ask them telephonically. They will go there and you accept it. If that be the reason, you can take Mr. Karita's number and then tell him, so that it can be faxed or sent.
They are not taking final. Hello, your Nafsi is very correct, my lord. In most of the matters, if they take a decision, citizens should not will not come to the court.
They will not come.
And they don't take the decision, so we are doing very lighter cases. This is the reason. They do not
Ask
take
them,
decision.
they will accept it by fax or something, what you call the WhatsApp or anything, and then act upon it.
Problem is that who is going to take the decision? That is the problem. Problem is there, in every field, and I'm saying it from the practical experience, in every field.
I think Mr. Gogoi will able to
Mr.
to
Gogoi
get
is
something.
saying the permit, I don't know how it is. The law says whether it is a lease, permit, there is no difference. From where he comes with a permit work, I don't fail to.
No, it's a permit area. Normally it's
Permit,
called,
but it's a legal, they lease for 2 years,
huh?
lease for,
Things can be granted from 10 years, 7 years, 2 years.
yes, 2 years, but it is there.
No. It's a, no, Mr. Das, he's right otherwise. In the rules, two separate languages are used. When it is for more than a particular period, then it is lease. Otherwise, it is a permit area.
Your lordship will say rule 3 and 4.
3 and 4.
There's a mining contract, there's a mining lease here.
Mining lease or mining contract or permit.
Or to grant mining lease or mining contract or any other concession or license or transit pass or permit. The mining lease or a mining contract or permit or any other concession license pass, permit or license or control or regulations of mining. Other sections under these rules shall be directly in respect of.
No, come to 8. 8 will tell you that it is for a particular period. Huh.
Grant of mining lease through competitive bidding. So, no mining lease shall be granted by the competent authority unless it is satisfied that there is evidence show that the area for which grant of mining lease is considered has been prospected earlier for mining minerals or existence of mining minerals therein has been established or otherwise. Minor mineral deposit.
And that contract is under 18.
Yes.
Contract is under 18. So therefore, they have their own reasons to use a particular word. And then 20 is mining contract.
But 16 is applicable.
No, that's okay. We are not on that, but he's using that word because of their terminology in their rules.
Rules. But permit and lease by lot.
No, it may be, the procedure may be same, but still the technical reasons, technically he'll have to say it's a contract area or it's a lease area.
In respect of the similar permit, I think in respect of the same petitioner, they have accepted.
No, that's okay. It's not that. He's using a terminology because of the act. At 2 o'clock.
Supplementary item 14 with 15 with 16. Bail hearing BA.
One year, 6 months, madam.
Yes.
Your last time, madam, one day thing, I'm just.
550 days. You are saying 10 witnesses examined,
One day thing.
10 witnesses listed and 3 examined.
Now, madam, I take your worships to.
Means the only difficulty is that Satyendra Kumar until.
Until
That-
also, madam, it is mentioned in that Muslim, that Muhammad Muslim case. Until also mentioned, madam, in that. The worship on Sariful Islam. And another is matter given the Chitta Vishwas. Yogi Prakash Maharaj. You got 3 and 4. That is the latest 13/7/23 inside. It is 13/7/23. Yogi Prakash we got 3 and 4 months. About 37 he mentioned. Article 21 he mentioned. That is what Sariful Islam, exactly by the 1 year 6 months. Sariful Islam have also decided on 22. They're working for the. Sariful Islam,
Yes.
they got 2 months. taking into consideration the fact that the petitioner is reported to be in custody since Soto and has suffered international for over 1 year, 6 months, and there being no likelihood of completion of the trial in the near future. This fact cannot be controverted by the learned counsel against the trial in the time to complete. Then your worship one another is Nitish Adhikari.
In this Nitish Adhikari won't be so what do you call this is on a different context. You see at page 2 in the middle, taking into consideration the
Fine.
period,
Period of sentence
but
and
without expressing any views.
that's naturally your worship was giving bail. Naturally, your worship cannot express or negative.
No, but the High Court, in view of various judgments, is required to assign reason why it is granting bail or why it is refusing bail. But the Supreme Court is not required to give what you call any reason,
But your worship.
or even section 37, which the Supreme Court otherwise says is required to be.
Ravi Prakash is the answer. 13/7/23.
Ravi Prakash, again, this case is 3.5 years.
Now that is but principle of 3 and 4, paragraph 3 and 4.
Ah.
We are informed that the trial has commenced, but only 1 out of 19 witnesses has been examined. Then, as regards the two in condition contained in section 37, learned counsel for the respondent state has been duly heard. So, first condition complied. So, for second condition is concerned, formation of opinion as to whether there are reasonable grounds to believe that the petitioner is not guilty, the state
May not be formed at this stage.
at this stage when he has already spent more than 3.5 years. In my case, 1.5 years.
No, not that you see.
So in 3.5
Supreme
years-
Court says it's not following section 37.
But so in custody, that is why there, the prolonged incarnation generally militates against the most precious fundamental right granted under 21. And in such a situation, the conditional liberty must override the statutory about the science. That is that I am saying. That your worship man. Some handle is even your worship man. Chitta Vishwas, my lord, that is also another. I have given also your worship. Chitta Vishwas, that is beside. On Chitta Vishwas, evidence was arrested and so and so. It appears that out of 10 witnesses cited to examine in support of the case, 4 witnesses have already been examined in the trial without expressing any opinion on the merits of your worship. Chitta Vishwas. I think, madam, because on this your worship may consider, madam, that is I am on that point. Nobody is coming up until after September. Nobody, no witness, nobody is coming up. So there is not. And another of this coordinate bench, my your worship may consider your worship is not bound, but your worship may single bench.
Okay.
And Muhammad Muslim also your worship. I think your worship is Muslim has decided to mark 28 to the I'm also getting money. And we also discussing this thing. But Muslim and Muhammad Muslim, that is also my all these cases I discussed my including just I do your worship now. In this case, one of almost all the cases have been discussed. Paragraph 19, 16, until 19 and 20.
There's a very recent, there's a very recent judgment.
The possible
Past.
last other day was.
No, no, no. I- what was written?
Otherwise, my 262 grams, that also can be divided.
No, 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 a different aspect altogether. Now, a very recent judgment has come from the Supreme Court issuing a direction to all the high courts that the constitutional courts shall not give a time frame for trial. This in this Muslim Ali, this Muhammad Muslim, you will get an observation here that is perhaps in para 16. In para 16 it says which requires the accused to be enlarged on bail if trial is not concluded within specified period. So on that specified period, I'm just trying to get if it is available or it has. No, no, not that. No, not that. But that consideration which has come in this Muhammad Muslim cannot be applied in view of the very recent judgment. 3 or 4 days back. 2 or 3 days back, it has been circulated. Means working days. I'm not counting holidays. In that judgment, the Supreme Court has taken cognizance of the fact that time-bound trial may not take place. Therefore, it has restrained the High Courts from passing any order giving a time frame to dispose of a matter. It says the constitutional courts.
Expeditiously as well. That way it is observed. Not a time limit. It is not contemplated. This is even 9 of the CRPC almost time limit. CRPC.
Yes, because this is why the trials are called sessions trial. You know the reason. Sessions trial would mean that it should complete within one session. So that is the internal purpose.
Something is mentioned here about that day-to-day hearing, but that to complete within such about so far the inquiry and other
sessions mean one session. That is why that
Proviso, my lord. Inquiry of the trial shall be completed within a period of 2 months from the date of filing of the charge sheet.
It's okay, not this. Just leave it aside because this is something I have heard, but we are not getting it. Okay, yes, what do you have to say? To overcome the rigors of section 37, Mr. H.R. Chaudhary has given us two citations where the Supreme Court has said that once he is incarcerated for, in one case, 1 year, 6 months, and in the other case, 3 years over, it says that sections 37 will not come in the way. Two thousand? No, just give me the citation. Huh? SCR, page 819. This is Nawaz. Huh? MOHD. MD.
Then only the difference in the fact is that the correspondent is one of the class. The permanent one. And here the fact is that it is the position of the subperson. That is 67 is section 67. Confession statement.
Okay. Okay. We'll release your today. You might get it tomorrow online. Item? Item 16, just. Okay. Yeah. Jumping to this again. Item 1.
I have always for the supply of goods, PDS. I was suspended thereafter, I was license was cancelled. Why don't I take your worship to page 147? The order starts at page.
Just a moment. Yes.
Now, the petitioner is a founder committee who was, because of delayed supply of PDS articles, he was suspended there, thereafter he was, license was cancelled. Now, I take your lordship to page 149, the earlier order. Which is given the whole fact, 149. So, also,
Page
149.
1. Yes.
The order, earlier order, which gives the whole fact.
Yes.
On page 150.
Yes.
Petitioner number 1 is the society registered in the Assam Property Development Act was granted some wholesale license to the under the Assam Public Distribution Article Ordinance. On 14/12/21, the license was suspended on the basis of certain reports which according to the petitioner were never furnished. Thereafter, a show cause notice was issued on 17/12/21 as to why the license should not be cancelled. That notice was replied by the petitioner, but by the, however, by the imperial order dated 10/3/22 license has been cancelled. While in WPC 724/21, the order of suspension dated 14/21 is the first matter of challenge. Subsequent petition 2332 of 22, the cancellation order dated 10/3/22 is the subject matter of challenge. On perusal of the order dated cancellation was revealed that such cancellation is on the ground of violation of condition 4781 of the license as well as 14 clause 14 and 26 of the other public of article order 82. Perusal of the aforesaid condition of license as well as the clause of the order 1982 would reveal that such allegations and extreme factual allegations in running of the business of the petition. Learning senior counsel the petitioner submitted that though a police case was registered, the case, the same has culminated in a final witness. The allegation ultimately appears to be one related to timely delivery of the previous article to the fair price shop. To be more specific, the delivery was to be made within 21 was not found to be completed. It is, however, not the case of the authority, but the delivery was not done at all, but was done beyond the time stipulated for such work. So it is for delay delivery.
No. In fact, if you come to page 172, their affidavit in opposition, it says that you have lifted 1860.75 quintal of NFSA rice, but you have the stock remaining 979 has been distributed and 881 quintal is lying with you unattended. Because if that be so, then you are definitely not. And your plea is that there are 2 laborers were ill.
Well, that appeal says 2 laborers, one my inspected, I said, shortage of labor and my daughter was ill.
No, but you see, whatever that be the reason, but 881 quintal is not a small quantity.
I challenged that cancellation order in an appeal. Appeal came with a perfunctory manner. My lord decided the appeal, I take your lordship to the appeal. Page 166. The 2 counts for which the appeal was that there are 2 cases under investigation, though final report has come out. And next case is that in one statement I take 166
166.
is the appeal order. I approach to the appellate authority is the appeal order.
But now you are challenging the appellate order.
finding in that page one.
No, it's just one. There is an actual your representation of 16, 12, 21. Where is that?
If it is, the lottery may look into page 200 and 201.
200, 201.
First is at 200, the next one is at 200.
No, your representation is of 16, 12, 21. 16, 12, 21.
This is for the assistant director of 24/12/20.
No, no. In your list of documents at serial number 11.
And my written statement, another one is at page 201 to the deputy commissioner.
No, no.
That is
Your index. At your index, serial number 11.
Proof of distribution.
No, no. Serial number 11 of your index.
Index for Annex J.
What is it? I don't know. Your list of dates. List of dates, serial number 11. 16, 12, 21. Representation dated 16, 12, 21.
21. One, two, three, that page 104.
104. No, this 16, 12, 21 is at page 113. Now you see, Mr. Roysotti, in the subsequent representation, there is an improvement. On 16/11, when you gave that representation, 13/11 that your daughter was ill or your staff was ill is not a case projected. Subsequently, when your license was suspended and then your termination was issued, then you came out with a plea that your daughter was ill and that staff were ill. That is not the initial representation of 16/12.
For delay, when the initial proceeding has come to a finding, that it is not a case of non-supply, it's a case of delay. Because that urge, conduct of taking cancellation of license And it was because it was dark. I kept the fully loaded truck before the police station. And the appellate authority decided that police investigation case is still pending. Investigation is going on, whereas final report has been submitted. Appellate
Where is the final report?
page one, it is page 108.
108. Final report, that 108 is the case with regard to theft 379.
No, no.
So there was no, there was no 379, therefore police case has to be closed.
There was nothing. The case of non-supply is not there. Only because they have said there was no statement as such my daughter and shortage of staff. Subsequently, in their affidavit, page 200 and 201, I have stated daughter was ill and I came to Guwahati, and my lord, page 201 says in last paragraph, due to illness of my daughter and short of labor, there are some labor. The allegation is that there is a delay anyway. For that, the license has been done. The appellate court held the investigation of 424 Algapur PPS case is matter is under investigation. In one case,
Where is that finding that it was a delayed case of delayed supply, delayed
page 167 last paragraph. and
167.
167 last paragraph and 168. But they have discussed about 12/5/23 and 24/12/21. The written statement filed by you. Not of 14/12/21. The written statement that they have considered is 12/5/23 and show cause reply 24/12/21. 24/12/21 is a page. uh, 200. Page 200, my lord.
Mr. Setia, you see at page 166. Last paragraph 166. On verbal instruction of the deputy commissioner, so and so lodged an FIR. Case was registered as so and so. Prior to that, second last paragraph, that on perusal record, it reveals that Moon Paul so and so submitted another report dated 7/12/21 to the deputy commissioner regarding balance stock of so and so and other lines in so and said that because there was a delayed distribution. That was on the day when you took steps for cancellation. On that day, the distribution was completed. There was only a delay. Correct. And then come to this. Page 167, last 6 lines. However, in his show cause reply dated so and so, he said so and so could not distribute in time. His written statement and show cause reply are contradictory to each other. But the statement of Moonpal, so and so, Harakandi are corroborative. If there is a delay, why cancellation of license? Yes.
Was dusk and I kept it before the police station. It was dark, so after sunset, I did not deliver it, so I kept it before the police station. So that nothing can be stolen from the site. I myself had kept it before the police station.
Where is that?
Initially in the invitation, I was taken. 97, you are working with the Hindu Madam. Code for that.
You did not keep it. You did not keep the truck before the police station. Come to page 221, paragraph 8.
Page 221 of their exhibit.
I don't know what is this, but 221. Paragraph 8.
That during in this IO has said clear as well as reminder to consultation. The inspector needs either of truck and both, but it is not, is the same number handover. Caesar, because it was
No, just read that.
number handover to Caesar list as a to supply department. Just keep the same vehicle as well as good important other.
So it is this what do you call food and civil supplies who has kept this truck in front of this police station, not you. Page. No, if you see, you have to give me more particulars. It is your own document which is showing that there was a delay. Correct. If there is a delay, then the rice will not be there. What will you confiscate? It is not that the rice exists and you could not do it. You see, if the police, Mr. I won't be able to accept that an ordinary citizen will not cooperate with the police. Police has the power to arrest. So therefore, saying that the persons have not cooperated with the police is something very difficult to understand. Number one. Number two, come to page 221 again. Just a moment.
98 your
I'll come to it. Page 221, paragraph 5. Correct. Paragraph 6. Para 9. Question of cooperation, where will it come? And now the only ground is that there was a delay, and you say that it is in violation. But once that is distributed, whether that will be enough to what you call will it be good enough to have a cancellation of license? That is something you have to show us. Where is that article distribution order? Pass it on. What are those provisions? 14, 16, something? 15, yes. Uh, 15. Now, Mr. Chetia, now you have to show us that there is any requirement that it should be distribution must be time bound or something like that. Because you are now saying that the cancellation is right and accepted because of violation of the clauses of Assam Public Distribution Articles Order. Now to show us that this was the mandate. The mandate I did not find it anywhere in this repetition, and if it is there, I have missed it. Reading file on a Diwali day was not very good. I will take it up at 2 o'clock. Just see if it is there. No, you see, it is your case now that there was a delay and that amounts to what do you call violation of the terms and conditions of this order. Now you have to show us something which links this to the delay links to non-compliance of the order. That is the only point you have to. Give this picture. Record to put it, no? Which one? Let him address also on that point. We'll take it up together. Item 2.
Last year, there was a statement made by the education department that they are in the proposal for the finance department. And copy of the SBE proposal sent to me was furnished and the project directed me to find out what is the present status of the proposal. Mother, from that follow-up, I was given I have matter that the finance department has approved of the proposal matter and the budget is available with the education department for disbursement. That's why
You take it up on Friday then? Next Monday? Oh, achha. We will adjourn it till Monday. Monday means 20.
57 financial application, 27 of October. So, the budget is available.
20, okay. No, the officer is not there, he's on election duty. Uh, um, Petitioner is represented. Mr. A. Shalyal, standing counsel for the Finance Department, has submitted that as per his instructions, the approval of funds for payment of contractual bill of the petitioner has been approved and communicated to the Education Department by communication dated 27/10/2023. Approval. The approval was done on approval of funds for payment to the petitioner was done on 27/10/2023, and accordingly submits that the funds are available with the Education Department for School Education Department for payment to the petitioner. Full stop. Mr. N.J. Khatania, learned counsel for the respondent number 1, submits that he is not aware of this said development and therefore prays for some time to obtain instructions. So it is submitted that the concerned officer is assigned to a election duty in Madhya Pradesh, state of Madhya Pradesh. Accordingly, on his prayer, lays the matter on 20/11/2023. Respondent number 2. Okay, he's for 2, not finance. Okay.
T4.
T4.
Yes, on that occasion, me and my limit, we are trying for the Indian government, we submitted. My limit senior is probably submitting for number 4, the matter. The record will also. Record is also the earlier repetition matter also.
Okay, is it available? Records? 1734. Yes, 1734, I think. It was right. Requisition की आना था ना से what must have been requisition of the records of 16/5. Okay, at 2 o'clock because it was long back we missed sight. At 2 o'clock, let him inquire. Okay. No, we don't have difficulty. If you want, you can. If you want to consult it, you consult it. We'll take it up at your convenience. If you want to do the hearing, we are ready. If you want some time for reconstruction of the record, please we'll accommodate that also. No, we'll have to permit it because we don't. We can't non-suit you because of that. Okay. 20. No, it will go to 30. These few days, I'll not be able to take up matters. Correct. It's not automatic. You hold it because if we are not hearing it today, you hold it. On the next day, you can give it. Mr. All sides are duly represented. Mr. M. Sharma, learned counsel for the petitioner, submits that inadvertently he misplaced his file and seeks some time to reconstruct his brief. Next paragraph. In the meanwhile, the registry shall tag the records of WPC 1734 of 2014, disposed of by order dated 2/6/2015. While listening the matter next. This matter may not be treated as pardon. It will come to this bench only, but it will not be because of the time limit. It will be improper to give it as a pardon. No, 30. You wanted on. You have difficulties on 5th. Oh, okay. 5/12/2023. You have difficulty on that day. Okay, on 7. Okay, on 7. Continue post lunch. Yes. Oh, okay. Oh, thank you. Thank you. This is the one. I'm glad you could place it. This was of 10/11. But this was circulated to us. So, we are of the view that since every high court and every court in the country has a huge pendency, the constitutional court should avoid temptation of fixing a time-bound schedule for disposal of any case before court, unless situation is extraordinary. This is the one. Thank you. Thank you. What do you call? I read it, but I can't. What do you call? Store it in the. What do you call? Store it in my memory. But thank you for this. In fact, I'll have to learn from you how to what you call track it so fast. No. But here you did a 70 work. This is otherwise an unreported case, not yet published. So therefore, to track it and show it to us is wonderful. When do you want? Choose a date. There's a calendar in front of you. Take it 20 or 22nd. Okay. I'm not keeping it pattern. There's a lot of botheration. it gives a lot of botheration. Because Mr. Roy, so the reason is not that. There is a frequent change in my bench. So therefore, it is very difficult to what you call have this because your case, in your case, no, not in your case, in some other matter. Because what happens is that after the change of roster, there is a very difficult time to come back to that subject. That is the difficulty. Because division bench, then last time it was bench 2, now it is bench 4. So very difficult. 22nd, okay. Mr. P.K. Roy Chaudhary, counsel for the petitioner, on the prayer made by Mr. M. Setyal, a government advocate, list matters from Judge John today, list on 22/11/2023.
Yeah, I have two items.
Huh.
Item number 14.
Item 14. Since you will give a short notice of 10 days, Friday. Till then, you don't take punitive steps. It's okay. Don't take coercive steps. Heard Mr. B. Das, Senior Counsel, assisted by Mr. D. Kalita, Counsel for the petitioner. Mr. Arak Govind and Standing Counsel for the Forest Department has submitted that he has tried to contact the concerned officials for relevant instructions. And it seeks some more time to address the court on the issue raised in this writ petition. Next, accordingly, next para. In this connection, in connection with this petition, the Lanet Senior Counsel for the petitioner has submitted that he has some urgency in the matter as because the 5th kist in respect of the sand permit area in question is falling due today, I-14/11/2023. So it is submitted that despite representation to the respondents that sand is not available in the permit area, the petitioner wants to surrender the says the extraction permit. Hence, it is submitted that at the next date of district, the respondent authorities may not take coercive steps against the petitioner for realization of case money. Next paragraph. Considering the nature of prayer made, the prayer for adjournment is allowed. List on when list on the list in the motion column on 17/11/2023 to stop till the next date of listing. The respondent authorities shall not take coercive steps against the petitioner for realization of 5th kist money. Next paragraph. Petitioner is
Why for taking a decision by the tendency should not be barred. If they want to take a decision.
okay. The pendency of this representation shall not be a bar for the respondent authorities to take an appropriate decision in the matter. This one, so and so. Okay. Oh, just a moment. Before that, you write the petitioner permitted to produce a certified copy of the order for the concerned authorities. Okay.
Daily list item 5/6.
Yes.
Particular has instruction that this matter has become
Infractions.
but the issue was whether in a consortium lot relying on that new horizon experience of the one party who is counted up. If the lawsuit kindly comes to page 21 now.
If it has become infectious, we don't go into it.
Just an indication,
Uh-huh.
two aspects of that.
Yes,
About 1.4 million.
yes,
The tenure of license fee for a period of 5 years plus 5 years subject to certificate. So
yes.
the tender was issued in 2014.
Okay.
Yes, yes, thank you for answering. Only that something which is left is my lord page if you're also seeing page 18.
18.
Yes.
Yes,
Was 5 my lord bills.
yes.
There must be accompanied by earnest. In this tender we participated and also submitted. Now since it's become effective, I need to get my earnest.
Okay.
Similar in other case also.
Okay. Mr. R. Okay. So in one case, I'll record your presence, one case I'll record his presence.
My senior friend is a senior counsel for railway.
Okay, joint, okay,
Assigned by Dr. Logan.
okay, okay. Mr. R. Dubey, on counsel for the petitioner, submits that by efflux of time, the matter has become infructuous. First of, however, he submits that he has deposited, the petitioner has deposited earnest money, and therefore, the disposal of this petition on being rendered infructuous would not be a bar for him to apply and receive in refund the earnest money deposit. First of, the prayer is allowed. The petition stands dismissed on having been rendered infructuous, with liberty to the petitioner to make appropriate application for refund of earnest money if so advised. In both cases, we just say Mr. S. C. Viswas, senior standing counsel for the NF Railway, as well as Dr. B. N. Gogoi, learned counsel for the NF Railways are present. Okay.
দুইটা আইটেমে উইথ আইএ ডিসপোজাল হৈছে ন 5
IA closed in view.
7
Item 7. Yes.
The petition has got the reading because the one letter I sent to them, they have not responded in it, it came back, returned back to me. Long pending is, but if they are satisfied with the, it may close it, keeping the option if there are any durance survive that they can come up with. And technically, I cannot appear because the Union of India is a party. At that moment of time, I was not a CPC launch.
I'll just say counsel for the petitioner is present. Sorry, you just write it there. Both sides are represented. On a in view of the nature of relief claimed in this writ petition, on the query of the court, the learned counsel for the petitioner has submitted that perhaps by efflux of time, the matter has become infructuous. It is also submitted that he had written a letter to the petitioner for instructions, but the letter along with the postal envelope has been returned back unserved. Next paragraph. Accordingly, as it appears that the matter has become infructuous, this petition stands closed. However, the petitioner would have liberty to approach the court again if so advised.
correspondent number in the CBC, SKMD is in.
Oh, acha. Both sides, you see, counsel for the petitioner as well as Mr. S.K. Mehdi, CGC, waiting for respondent number 5 are present. Okay.
Item 8.
Just a moment. Just.
850.
Yes. You want another day or after some time? 3 o'clock. Okay. No, this is this will hardly require any instructions. It was a disciplinary proceeding where he was terminated. The labor what you call authorities, this labor court upheld the termination. So we are only just to see that whether the termination can be what you call sustainable or not. So that's the only issue. Okay. Okay, counsel for the petitioner is present. Mr. A. Sandilya, learned counsel, submits that he is not on record and he prays for adjournment so as to enable him to file a wakalatnama in the matter. Matter stands adjourned today, list after 2 weeks.
Item 9.
Just a moment. Godown rental. Claim for godown rental. Yes. Mr. Gowai. Claim for godown rental. You have stored rice there. No, come to page 32. But Mr. KM Hassan, Mr. Hassan, you better take instructions. You know what will happen? We will how much is the goods stored?
299 bags. 299 bags.
299 bags. No, no, I'll just tell you what will happen. This, where is the agreement for rent? That's not there.
In the computer 19.
19. No, this is a tenancy agreement.
Right.
You see, with the government, is there any writing that they will give you this this? So therefore, you see, existence of contract cannot be an implied contract to pay rent. So, and second thing is that if it's a question of you see, there's no landlord tenancy agreement. There's no record of anything showing that they bound themselves. You see, when they store rice, you did not say that at that point of time that you will be required to pay me this rent.
In the long back, my lord, in the year 2011, my lord, I made a resignation before the one director. So that I am bearing a loss of 6,000 per month. This is net increase by 15 million. That also my lord, I even died to the sea of the
Mr. Hassan, there are a lot of difficulties. You see, number one, Registration Act.
Registration.
Right to birth sentence. This is birth sentence. Or the Registration Act. R4. Yes, yes. Book serial number R4. R4. You see, this we are not getting the book. Section 49 of the Registration Act. It says that what you call document which is compulsory required to be registered shall not be read in evidence. That is the purport of section 49. Now, this rent agreement you say that is rupees 6,000. You also say there that you are also using it is a common godown. Correct. So in a common godown, when you give a representation for a common godown, that means you are only proportionately using the space. And then you see a lot of things. You are reminding me of many civil laws. You see, number one, if you take on Zimma, your under the Contract Act, your situation is like a bailer of the goods. So it's a duty of the bailer to return the goods in the same condition. Now your rice is a perishable item, and it must have gone rotten by now. Correct. But you see the this in the Contract Act, bailer and bailee. That's why I said you better take instructions. Contract Act. জাতীয় থাকলে পারে A to side.
I don't think any such.
You see, under the contract of bailer and bailee, that will come. No, it's just no, there is not that. But your there's a responsibility given. You see, 158 first. 158 will come when there is a contract. Correct. Now see 159. Now, this is something which would be subject to, according to my understanding, only the civil court. But this becomes a disputed question of fact because I told you, your own representation shows that only it is used as your common godown. Now you say that you are suffering a loss of 6,000. That can't happen because you are utilizing that. That is one part. Second part, you come to section 170. So it is only for that lien. If it is there now, even to show lien, there should be an agreement or there's some sort of understanding. So these are among the others, these are the major reasons why read code would find it very difficult to arrive at a finding. Big instructions, because you'll also find in the same this 158 I showed you, some sections here or there, 5 or 6 sections here or there, you will find there's a provision that you have a duty to return it back 145 or something, to return it back in the same condition. Whatever it is, I won't remember the provision so accurately now.
152 says defined limit. When there is a no contract method, there is no liability.
No, the liability is gratuitous. The word used there in the provision is goods kept gratuitously. 159. Okay. Correct. So, these things are there. Then Registration Act 49. 49 says the document which require registration shall not be read in evidence. Now you see effect of non-registration, that is in 49. Huh? That is one. There's a second aspect. There's a lot of misconception that that in a read code you don't need evidence. It's a misconception because I have authored a judgment. No. You see, the admission is not a contract of bailer and bailee. There is no admission so far as rent is concerned. So therefore, it doesn't matter if it's a complex agreement. Every part is a distinct what you call value. What I'm trying to say is that there being no contract, and the misconception to the effect that in a read code you don't need evidence is incorrect, because I have authored a judgment where I have held that pleadings in a read code itself is an evidence. That is why we take action against the person giving a wrong affidavit by contempt of court, because we say that incorrect evidence has been led, and therefore in a read code we do it. So therefore, I have authored a judgment where I have held that in a read petition, this pleading itself becomes an evidence. So therefore, I am using this word with full understanding. Evidence means a read petition is also an evidence, and if it is evidence, then 49 debars me from looking into a document, except for collateral purpose. Now that collateral purpose gets defeated again, I'll come back to same thing, that your godown, a part of it was used for that. Correct. The ground was emptied.
Yes.
Okay, very good. No, not compensation. Okay. No, that is okay. You see, some people will fight just for not for money. It will be for what you call what they consider is their right. And they are not wrong when they are fighting for a right, because what happens is that these people, maybe he was not treated well when the goods were kept, and then those high-handedness must have been there, and therefore
That's why he repeatedly approached my head.
What is your trade? You appear to be a grocery shopkeeper.
Yes.
Then you did not suffer a loss. Okay. Mr. K. M. Hassan, counsel for the petitioner, as well as Mr. K. Gugoi, done as additional senior government advocate appearing for the respondents, etc. The learned counsel for the petitioner seeks some time to obtain instructions. Matter is adjourned today, at least after 2 weeks. But you reminded me of any provisions. Otherwise, I would have forgotten sitting in this bench. Bench one, I would have remembered, but in this bench, I would have forgotten.
Next
Okay.